Good morning, dear students. I, Dr. Tiwari, Principal SK Law College, Muzaffarpur, once again appear for you to discuss the today's topics. Today, I have to discuss the topics of Negotiable Instruments Act. Earlier in the running classes, many topics have already been discussed. The Negotiable Instruments Act was enacted and come into force in December 1881. It deals with negotiable instruments such as promissory note defined under Section 4, Bill of Exchange under Section 5, and cheques under Section 6 of Negotiable Instruments Act. The said Act will herein referred to as the original Act by the Banking, Public Financial Institutions and Negotiable Instruments Laws Amendment Act 1988. Certain amendments were made by the Parliament during these amendments. Now, I have to discuss in course of that. In course of the dishonour of the cheque, a banker is bound to honour the customer's cheque when there are sufficient funds properly applicable towards payment available. If cheque is returned even when sufficient funds are available, this dishonour is a breach of contract and may invite legal course on the part of the customer. Due to these reasons, I herewith explain the balance in the customer's account is considered not available or applicable for payment. These are the followings. Number 1, payment is stopped by the customer. Number 2, death of the customers. And number 3, garnishee order or the attachment order passed by the competent courts and or revenue authorities. Number 3, set of rights to recover debts and due to banks from the customers. Now I want to mention the reasons of dishonour in this way. When a cheque is returned unpaid by the bank for reasons: number 1, insufficiency of the funds; number 2, no arrangement; number 3, exits arrangements; number 4, payment stopped; and number 5, referred to drawers; and at last number 6, closure of account by the drawer. A cheque is considered to have dishonoured and the drawer is considered to have committed an offence. But when the drawer is intimated the pay that he shall not present the cheques without his prior consent, in that event such cases will not fall within the frame of the Section 138 to 147 of Negotiable Instruments Act. I want to make out these as under Section 138 that deals with the dishonour of cheques for insufficiency of the funds etc. And under Section 139's presumptions in favour of the holders. Under Section 140, defence which may not be allowed in any prosecutions under Sections 138. Under Sections 141, offences by the companies. In the company law classes, you would come to know or you would get detailed knowledge regarding the responsibility of the criminal liability of the company. And under Sections 142, which tells the cognizances of the offences. Under Section 143, power of courts for the summary trial of the case. And under Sections 144, that says the modes of the sentence of the summons, service of the summons. That says under Section 145, evidence shall be taken on the affidavit, and under Section 146, bank slips shall be the prima facie evidence of these certain facts. And at last, under Sections 147, offence to be compoundable. It means such types of offence can be compromised among the parties before whenever the trial is going on. Again, if we go through the Section 138 of Negotiable Instruments Act, we must know the banks are under a duty of confidentiality as to a customer is State of Accounts Rajkumar Khurana versus State of Delhi, SCC 2009, Volume 6, page number 72. The drawer is punishable with imprisonment extending up to 1 year or with fine, extending up to twice the amount of the check mentioned on it or with both. Now this term of imprisonment has been made 2 years by the Act number 55 of 2002, which is effective from 6th February 2003. Now next to that, dishonour of checks for insufficiency of the funds, where any check drawn by persons on an account maintained by him with a banker for payment of any amount of money to another persons from out of the account for discharge, in which or any part of any debt or other liability is returned by the bank unpaid, either because of that amount of money is insufficient to honor the checks or that it exceeds the amount by an agreement made with the banks. Such persons shall be deemed to have committed an offence and without prejudice to any other provisions of this Act, be punished with imprisonment for a term which may be extended to 2 years, or with fine, or may extend to twice the amount of the checks once again, or with both, provided 3 things are done hereby. Number 1, the check has been presented within 3 months of its validity period. Keep it in mind. Number 2, a demand for payment is made notice within 30 days of the return of check. And number 3, the drawer fails to make payment within 15 days of receipt of notice. Negotiable Instruments Act 1881 was amended in this year 1988, as we have already previously discussed it. Next to that, case references in regard of dishonour of the checks. In that particular instance, I have to say that in the case of Srimati Bhupinder Lima versus State of Andhra Pradesh 2000 SEC, the court held that criminal liability cannot be fastened on the heirs or the legal representatives. It means the legal heirs of the offenders shall not be punished anyhow. Next to that, in the case of G. Venkata Manais versus Sialkundu Venkata Suralu 1999, the court held that an offence is committed even if a check is returned on account of the closure of the accounts. Further, I want to say that offences by the companies, as I discussed earlier, in the case of Messrs. Chahal Engineering and Constructions Limited versus Burma Plywoods Company 1994, the court held that if the persons committing an offence is a company, then every person who is responsible for such offence as well as the company shall be deemed to be guilty of the offence. Now, one thing, the features of the Negotiable Instruments Act in course of the above sections, as we mentioned above, the summary trial by the courts. All offences under sections 138 read with section 141 shall be tried by a judicial magistrate or by metropolitan magistrate of the first class, and the provisions of section 262 to 265 of the Code of Criminal Procedure (CRPC) shall apply for the summary trial. In the case of any convictions in the summary trial under this sections, it shall be lawful for the magistrate of first class to pass sentence of imprisonment for a term not exceeding 1 year and an amount of fine for exceeding ₹5,000, and mode of service of the summons. The process under which the service of summons, as I discussed earlier, the magistrate issuing summons to an accused or a witness may direct a copy of summons to be served by speed post or by such courier services as are approved by Court of Sessions. Evidence shall be taken on affidavit. Evidence of the complaint may be given by him on affidavit and may, subject to all the exceptions, be read in evidence of any inquiry or trial. Next to that, bank slips shall be the prima facie evidence of this on the certain facts. The court shall, on productions of the bank slips or memo having thereon the official mark denoting that the check has been dishonoured, presume the fact of dishonour of such unless and until such fact is disapproved. Now, one thing is very important for us: the compoundability of the offences. The compoundability of the offences are the subject matters of the Criminal Procedure Code, since the procedure the provisions of the procedures is going on, and under such procedure an offender can be convicted. In the case of Sadanand Bhadran versus M. Sunil Kumar 1998 CLJ, the court held that every offence punishable under this act shall be compundable. Pay of a cheque cannot initiate prosecutions for an offence under section 138 for its dishonour for the second time, if he had not initiated such prosecutions on the earlier cause of action. Friends, in concluding remarks, the topics is too infinitive, but you can successfully get through it if you just make an honest and your best effort. I think you would get success, of course, in understanding the topics of today. Thanks a lot. Have a nice day.